Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Séverine Sentier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law.
Good morning, good afternoon, or good evening, depending on what time you are listening to this podcast. I am here with Dr. Tim Dodsworth.
Hello.
And Mrs. Maggie Hemsworth.
Hi.
From Exeter University. And we are doing a podcast, Unpacking Contract Law. And the case we are looking at today is Wells and Devani. And I am Dr. Séverine Sentier. Wells and Devani, the quick facts, or the facts quickly. Mr. Wells was a property developer who had trouble selling flats he had just completed, and he was given the details of Mr. Devani, who was an estate agent. Wells contacted Devani over the phone, and during that phone conversation, Devani told Wells that his commission for him to introduce and eventually find somebody to buy the flats would be 2%. But at no point did Devani specify what would trigger the obligation for Mr. Wells to pay the commission. The flats were sold, and Devani claimed his commission, but Wells refused to pay. And so Devani issued proceedings. At first instance, the court decided that Devani indeed had a right to receive the commission. There was a valid and binding contract which was created orally, and even though an essential term, i.e. the trigger event upon which the obligation to pay the commission arose, was not defined, nevertheless there was a clear and completed contract. The Court of Appeal reversed this and said there was no contract. It was an incomplete agreement, which was not enforceable if an essential term was missing. The event triggering the obligation to pay was clearly essential, and so therefore there was no valid contract. Leave to appeal to the Supreme Court was granted. And 3 questions were asked to the Supreme Court. The first one, was the oral contract complete and enforceable, even though the event triggering the obligation to pay the commission was not expressly identified? Second, was it necessary to imply a term specifying the trigger event? The last point was whether there was a breach by Mr. Devani of the estate agent 1979, which we will not go into details. So here we are, Supreme Court decision. To me, the question is, did it need to go to the Supreme Court? Over to you, Maggie and Tim.
Well, I would say not obvious.
Yes.
You've got quite distinguished judges in the Court of Appeal, in particular Lord Justice Lewison, who's so well known for anything to do with contract interpretation. He's written basically the Bible on that subject, and that's really, homage is done to him, if you like, in the Supreme Court. Quite careful to pay respect to him. He is a very well-known figure. So if you've got a contractual setting that might have wide public interest and relevance to many people, particularly estate agents, and buying and selling transactions of land are so commonplace now, I think that in itself would probably have enabled the Supreme Court to grant permission to go to them on these particular points. It is of general public interest, and therefore you've obviously got some doubt, if you've got doubt at the Court of Appeal level with a very distinguished judge or judges as you had in that case. So I would say that this is law in action. I would say well done, English and Welsh system. Our system of justice, actually, it was working very well in that instance.
I agree that there's some clarification in there, and I think the fact that we do have the Estate Agent Act, which I know we're not going to cover today in there, does mean that potentially the common law aspect did need to be clear in this instance. Did it need to go to the Supreme Court? I really don't think so. I must admit, I'm going to disagree with you on that one, Maggie. I think the point of law that we're trying to address here is really not that difficult to grapple with. Granted, I think they do go around a little bit in terms of implied term. Should it be an implied term, or should it be sorted in the sense of interpretation? So that's really where I stand on this. I would agree with you, Severine. I don't think it should have possibly gone all the way up to the Supreme Court on the point of law.
Can I just argue the toss on that? It was
Please.
left in the Court of Appeal such that the estate agent had no claim, and that if the law had been left in that position, that is potentially a difficult situation, because there might be other transactions of this nature where the estate agent has been the effective cause of the sale, which is the language of the legislation, and would not have any remedy at all. So do we think that would be appropriate, given that the estate agent had found the buyer, the purchase had been completed, and yet he had no claim at all, zero? An unjust enrichment, although that's not really my area, I don't think that would have given any remedy. So you would have a situation.
No, I don't think unjust enrichment would have helped.
So
you
would be left in a situation where, if this is repeated again, no remedy at all to the estate agent. So it perhaps would be unsatisfactory, I would say, or at least an arguable point to justify going to the Supreme Court. I mean, I agree thus far to the extent that the context of this is, I think, particularly important. And so I doubt myself whether it can be extrapolated, if you like, into many other walks of life. So to that extent, it is quite a narrow decision, in a sense, because you've got two sophisticated parties. I mean, the seller was a developer, and so he must have dealt with estate agents and buying and selling and how this is done many times before. So it's not like you or I perhaps doing a sale once in a lifetime sort of instance. These were both sophisticated entities, and so I think that background is particularly important. And the Estate Agents Act, although we're not going to discuss that, I think that's also particularly important, because it gives the estate agent the right to commission whatever it has been agreed at, if he or she is the effective cause of the sale. And so, that is a significant background part of law. So the factual matrix, I think, also includes the legal matrix, certainly where the parties are taken to be aware of that. And I think these sophisticated parties, as I say, would have been aware of that.
The reason why I ask, why on earth did it need to reach the Supreme Court? Because I agree with you that the correct decision, was reached. But so it's interestingly, you both talk about clarification interpretation. And yet, as it has been written by academics, there is nevertheless a confusion between the related and yet distinct doctrines of interpretation on the one hand, and then implied terms. And also, so can you untangle some of that? Because did the court, how can the court imply a term, or can they imply a term for the purpose of creating a contract? So all these are not entirely clear.
Well, that's isn't it? That is the far more interesting point, I suppose. And the difference here is, if you look at the Supreme Court, the way they approached it, I would call that truly Hoffmannian, if that is a word, paying homage to Lord Hoffman. And those of us who are paid up members of his fan club would be applauding that approach, and I certainly am a paid up member of Lord Hoffman's fan club. I think he would be saying, what's the problem with this? This is an obviously correct decision, because he would be placing quite a lot of emphasis on the context and quite a lot of emphasis on, he uses the term speaker meaning as opposed to word meaning, which is a sort of related idea here. The inference, what was obvious to them, not in an implied term sense, in the way that we use this obviousness test, not in that sense at all, but what was an inference as to their actual intent. So there's the real difference between the finding here. The finding here is an actual intent, although not articulated. Wholly oral contract anyway, so you wouldn't have anything written down, fine. You didn't have anything actually orally expressed as we are expressing it now. Nevertheless, the parties, given, as I keep saying, their sophisticated nature, they were both working on that assumption that the commission would be payable 2% on completion. But nobody actually had to say those words because they both knew it and both accepted it as so. So that finding is an inference of actual behaviour, actual agreement, whereas implied term, there is no actual agreement. It's a different process. It is saying if they had thought about it, the answer would have definitely been this. And that is, I suppose, subtly different. And a pedant might say, you end up in the same end result. So why are we labouring this? And perhaps Lord Hoffman would say that, as he said about the Supreme Court more recently. He said extrajudicially, I think in 2018, sometimes the Supreme Court currently makes heavy weather of things. They're sort of labouring things that, in his great expertise and brain capacity, would see as blindingly obvious. And I think Wells and Devani falls arguably into Lord Hoffman's blindingly obviously correct outcome, as it were, but not by an implied term, I would say.
Yes, I'd agree with that. I have a difficulty with the implied term idea. One is that, of course, if we're doing it via necessity, for example, then the inference is that we need to imply this term to give it business efficacy, which means, of course, that there is a certain amount of business efficacy lacking, which means we can't then start implying that. That's the whole purpose of the contract in the first place. That would be my first one. So if anything, I think we'd need to go via the officious bystander test. And that's the only one that would, in my mind, at least work. And I think, Maggie, you were hinting towards that in what you were saying. So I think we need to be careful with the implied term. And I must admit, I don't think there's any need for that. I think we can find it through interpretation or even construction of the agreement quite easily.
I mean, the only danger area, to my mind, of the implied term argument it was the problem that Lord Lewison came across, because the evidence was apparently, I don't know, and there's not a lot of detail about it, I think, in the judgments, but there was some evidence that actually in the market there are different trigger moments for the payment of the estate agent's commission. I mean, you and I, if we only did one sale in our lifetime, our family home or whatever, probably wouldn't appreciate that might be so, but apparently it is. So perhaps the commission might be payable at exchange or some other point in finding an interested party, whether or not they actually complete the thing. So I think that might have made it more difficult for the implied term argument, and I think that was the problem that Lord Justice Lewison had in his mind for implied term.
Yeah, I mean, so the one potential problem that I have is, so Lord Kitchen, in the Supreme Court did disagree with Lord Justice Lewison, and even though you two do not really have a problem with the decision, there is one point that Lord Kitchen comes close when he says at paragraph 33, it seems to me that it is possible to imply something that is so obvious that it goes without saying. And he says that I do not accept that there is any general rule that it is not possible to imply a term into an agreement to render it sufficiently certain or to complete.
Yes, why is that a problem? Why is that contentious?
So does he not come here close to
why is that what he says there?
Two?
Why is that contentious or a problem? Because
how can you imply a term, playing devil's advocate, in order to create a contract? That comes dangerously close to mixing the interpretation and implication and formation. They are different areas.
I would say Lord Hoffman would say, no, that is an artificial distinction. When you're talking about an implied term, you are not creating any contract. The parties have created their own contract. All the court is doing is, if you like, dotting the I's and crossing the T's of what was bound to have been in the deal. So this business efficacy idea is sort of a phrase to try and grapple with that, isn't it, really? And the officious bystander is just another way of expressing the same thing. I think if you look at the Philips Electronic case, where Lord Bingham is trying to explain to us when it is possible to imply a term and when it is not, he's saying it's not good enough to say that had they thought of it, they would have made some provision. That's not good enough, because that would be doing what you're worried about, Severin, which is creating a contract, and English law never does that. So he says you've got to go further than that. You've got to be able to say not only would they have made a provision, but you need, as a court, to be able to see, that's identify, not create, what that provision would have been. So if it's not sufficiently clear or not sufficiently narrowed down to a single one thing, then you're in difficulties with the implied term. And so that's why I have this slight wobble or unease about implied term in Wells and Devani, simply because there was some evidence that commission might have been payable at different points other than completion. And so that's why, to my mind, is a little bit wobbly on that one. So I'm not surprised at all, therefore, that was rather a sort of secondary thought offered by the Supreme Court, Lord Kitchen. That's not really the main reasoning.
Yeah.
And I personally, I can't see any problem with putting an implied term in to complete what is written down, if you like, in a contract, but you're still not creating the contract. You're not creating the term. You're simply articulating what term and only what term and only the content that the parties would themselves have articulated.
The line is very close. I mean, as I said, perhaps it's also interesting, something that I haven't mentioned in the fact, the Supreme Court so all the way through when the Devani and Mr. Wells were making were explaining what happened, it is perhaps important to point out that the courts did not want to accept Wells' expression of, what was recalled, what really happened. So they completely disregarded this, and there seemed to be some inference that he, after having sold 7 flats, he suddenly realized he had an awful lot of money to pay, and perhaps was not the nicest of person. So that is
well, yes, the evidence is not in his favor.
Is not in his favor. So Devani and estate agents always get the brunt of people, but in this particular case, he was the honest person out of the 2 people. So I don't have a problem with the decision. It's just we always say that things come in chronological order, and therefore the implication of term in order to create a contract, even though admittedly that's not necessarily the first time it's been done. It's just sometimes make it difficult. The court, the Supreme Court, recently in Ireland and Britain, went into some length to really make the distinction with implied terms and interpretation.
But in Ireland and Britain, though, Severine, that's really about interpretation rather than implication.
Sorry, yeah, no, but the process, that they are 2 distinct processes. The Supreme Court went into some lengths to make the 2 notions separate, and perhaps here they are. Anyway, that's we.
Well, that's the point. For example, Lord Hoffman would say you're making heavy weather on those very pedantic distinctions. All you're trying to do is work out, is there a deal, and what is the deal?
So taking a pragmatic decision. Can we move on perhaps from this and another interesting thing, or a fact of the case that perhaps we're going to discuss and disagree on is the words were not expressly spoken and yet the court considered that nevertheless the phone conversation was such that they clearly meant it that the trigger was the sale and the completion of the sale. So I think it's Professor Paul Davies who said, can you raise the issue that you can't really interpret silence? Can that be right?
Well, I quite like Lord Briggs' argument, actually, on that point, where he talks about the broom and someone rings at the doorbell and you hand over the broom. That is quite a compelling argument. And I think, absolutely, I think a certain amount of silence in a contract, and I think this is where, on other points, the Supreme Court might have got it wrong. We can have a look at M&S and BNP Paribas, I think, would be one of those examples. Silence, once the parties are communicating, as long as it's not acceptance, and again, you could by previous expression get around that. I think silence in itself tends to have a meaning. Even when we're communicating, so long as we have that communication, and by communication it would probably mean as long as we're in contractual negotiations, your silence could certainly mean something. If I were to make a particularly heavy argument here and both of you were silent on that point, I think that would be saying more than necessarily saying something.
No, it might just be politeness.
Well, that says the same thing.
Which we know is uncharacteristic, nevertheless.
At least in this circle.
I think it's back to the context again. The context of sophisticated owner of property, developer, not just a single owner, as it were, and an agent. It's a question of inference rather than what's made explicit. So I wouldn't even describe that as silence. I would say it's heavy in the conversation, although not spoken. And the broom examples of Lord Briggs, I think he should have made explicit homage to Lord Hoffman. I'm going to welly in again in favour of Lord Hoffman, because he has written extrajudicially, 2018 I think it was, when he was talking about speaker meaning, and he gives 2 examples of he can get tickets for a rugby match, and so a friend of his says to him, "Oh, can you get me one?" And the natural inference is that not that it's a gift, that he'll be paid for it, reimbursed for it. And another one he gives, I've got tickets to see Andras Schiff playing in the Barbican or somewhere. I can give you a lift if you like. And the inference is that you would actually also take him home again, not leave him in the Barbican. Now, you might say that, well, that's silence. Nobody said that. But the natural inference in that particular setting is that, yes, you'd pay for the wretched rugby ticket, and yes, you'd actually take him home and not abandon him at midnight.
Well, presumably, though, there is a difference there between silence being an inference generally and silence then having contractual force. So I think we do need to be a little bit careful on the distinction.
Generally, silence is equivocal, isn't it? We all know that.
Yeah.
But that's why I keep banging on about the context here and the background and these particular parties. Silence, if you like, was pregnant. If not pregnant, then heavy.
Heavy with meaning.
Yes.
Although we're saying silence, I mean, there wasn't outright silence between the parties.
No.
It may still have been said, although not in those words, as one might say, one might argue.
Well, I suppose that is the practical problem that courts have, or advocates have, and certainly the solicitors would have, trying to draw up witness statements. This is on recollection of oral conversations over the telephone, probably months ago, when one guy wants to avoid having to pay anything and the other guy wants his full cut. So, who are you going to believe? And it's a question of memories fading naturally, innocently, and then coloured, obviously, by their own self-interest. So, that's a particular practical problem.
Well, I think there's many practical problems. I mean, one of the big questions I'm asking myself is, why on earth didn't he send this earlier? But I think we may have to, that's something that clearly, I think estate agents know that they need to send this stuff. Did he just forget?
Yes, I think so. So that probably this is really about a mistake, if you like, in a loose sense, in the estate agent's admin side, and had he played it exactly by the letter with what's required with the Estate Agents Act, you wouldn't have been in the Supreme Court arguing about, is this inference, is this explicit, is this an implied term, is this interpretation? We wouldn't have gone down that sorry road.
And on that, really, I'm wondering, what is this basis then for the interpretation? What are we saying is coming? So the issue is when is this consideration due? Right. So what are we saying? What are we actually interpreting here?
The fact that they had not expressly voiced the fact that the trigger was on completion of the sales. That's what it is all about, and the way the court said that you can. So on this, I agree with you, Maggie, that the silent. So the court kitchen linked it all back to. So in order to decide this, linked it all back to the intention. It was absolutely clear, as you both have said, that of course there was a commission which had to be paid, and the court went into quite a lot of details about the way when there is a sale or the conversation which is being done between a client and an estate agent, find me a house, all these things. So these colloquialism, is that a word?
Yeah.
So therefore, that's why on this aspect the context is important, and therefore the silence indeed was pregnant with meaning. But the court heavily relied on, so again, the context in order to decide whether there was.
And you talk about.
So quite the statement is then pay me 2%.
Yeah, that was that.
And the addition would then be upon completion.
That was the only thing that missing.
Yes.
Because it's upon completion, and so therefore it is deducted from the price that was reached, or that was the price that was paid by the person who bought.
So it's just a question of what's implicit.
Yeah.
And you were talking earlier about the Ashley and Blewett problem. This is a million miles from that.
We should add that was in a in the discussion before we started recording.
Well, just to refer to that case, Ashley and Blewett, I would say it's a million miles from that.
Yeah.
These were arm's length transaction, as it were, dealings. The parties weren't known to one another previously. It was obviously a commercial discussion, not in a pub, although, of course, where you're having the discussion is not necessarily significant. But it was heavy with serious commercial and legal intention.
Yes.
So in terms of formation or finality, I suppose one should say, the finality and formation of the agreement, I don't think that was a particular problem, as long as you think the law is such that you can add an implied term in order to show its complete form, as it were. And that's where we were arguing earlier. Is it appropriate to use an implied term in order to fill that gap in that situation? And I would say, well, I don't see what's the problem with that.
Yeah, well, we won't go back into it.
Won't go back over that. Are we agreeing to disagree then on that?
I think on the point of, indeed it's not at all like Blue and Ashley, and indeed the court, went to, or Kitchen, for the majority, went to some length to say that here there was the reason why it was so this was not a problem, that the the trigger was not mentioned, was because so looking again at the context, it was absolutely clear that commission would be payable, that something, that it was a transaction. He had contacted the estate agent for the purpose of finding a client, finding something. And as the court also went to some length to say, there was performance of it was performed. So the court, Lord Kitchen reiterated the very well-known fact that the courts are loath to unmake contract. And so here the importance of performance was also important to establish that there clearly was an intention. So all those are crucial for the decision.
I'll tell you one other interesting thing. If you look at, that's a unanimous decision of the Supreme Court, and it includes Lord Sumption.
Yes,
who was, well, in fairness to him, I would say he's normally much stricter about language and express terms, and I suppose the other end of the spectrum, possibly from Lord Hoffman, in terms of giving a lot of weight to the context and the background. He leans, I would say, towards textualism rather than contextualism, I think, just inherently naturally. That's not meaning any disrespect. That's just, the way each judge would naturally approach things. And yet he had no difficulty in agreeing with Lord Kitchen's analysis and conclusions. I think that's quite significant then.
Yes, I do agree. The assumption is quite the market individualist, certainty being one of the overriding factors for him. And I think him agreeing with this case probably says something about how we started. It possibly is questionable how this got to the Supreme Court, although I think we have found good reasons.
Yes.
I think that one of the main aspects here is also the Estate Agent Act. The fact that the Act puts so much emphasis on the fact that we do need the certainty for the agreement to come into existence, probably weighed on their mind at the same time.
Yes.
Well, I suppose that the real thrust or purpose of the Estate Agent Act is to protect Joe Public consumer who needs the certainty and the formalities that the Act requires of the professional there, because there is a natural imbalance in their knowledge and their experience of these sorts of transactions. And I come back to the context again. I don't think that Mr. Wells and Mr. Devani needed that close care, if you like, of the law. They were able to look out for themselves. It's just that the estate agent made a mess of his paperwork.
I don't think we quite nailed it on the head what the interpretation is, because the interpretation, as far as I understand it, is coming out of the silence. And I think we may need to...
Well, I just think it's a pedantic, Lord Newberger would say, a sterile argument.
Fair point.
You could equally call that construction, because it is taking into account the context and the background and the inference between the parties. So I don't think it matters.
I would argue that it is closer to construction, actually, yes.
Yeah.
Less so interpretation.
Yeah, so I don't think but I don't really think it matters what word you use, but I think if you're being pedantic, I'd probably call this construction rather than interpretation.
I am indeed being pedantic.
And here you are, the two of you, telling me yesterday in the thing that construction and interpretation are not the same. And what
No, that's only Maggie. I'd like to say this is Maggie.
Honest to you, it doesn't matter. You end up the same thing.
And yet yesterday, no, Severine, they are different.
Well, they are. They are different things, but I think I did say
No victories given that
pedantic
easily.
argument.
I will agree it is a pedantic point, but yes, if I'm going to go down in history, then it is going to be on the basis of being pedantic,
That's
I think.
fine. I'm happy with that.
Good. We're talking about what we're trying to fill in, and I think that's a point that Pilkington and Eldridge make, is what is the... at the formation stage, what are we lacking? And they make 4 points. I think they say it could be a lack of finality, it could be an incompleteness, it could be the vagueness, or it could be the illusory consideration. And they conclude that this has to fall in the incompleteness category.
Yeah, but I don't know that it gets you anywhere. But we kind of agree on that, don't we? Well, no, I mean, I don't know. There's some points of differences along the way, but we agree at the outcome.
Wait,
don't we?
we actually agree on,
Well, good for us, bad for the podcast.
You want to fight, do you? Fight. Ah, dear. I can remember Lewison when he was a young barrister. He won't remember me. I was a trainee article clerk. And he was specialist landlord and tenant, young barrister, on the fast track upwards in the early 80s.
One other point I thought we could address would be Lady Arden's idea of there being a unilateral contract which then turns into a bilateral contract, which isn't picked up, I don't think, at the Supreme Court stage at all. I don't know whether we want to...
No, I don't know. I don't understand. Where's she going with that? It's a pity that's a lockdown, isn't it, Severin? It's a pity there's a lockdown, because you really think Tim needs to get out more.
Yeah.
Oh dear. I don't think the lockdown in any kind of way... I think I needed to get out before then.
Okay, because I think we need to wrap this up. Okay, so to conclude and to end, what do we think? A bad, a good, an ugly decision?
The right decision, I think, overall. Possibly not the most elegant in terms of doctrinal coherence or progress through the courts, I'd say. But generally, I think I agree with the outcome, and I'm quite happy with where that stands.
Well, I agree. Right outcome, right reasoning, at least on inference. I suppose for people writing textbooks or teaching the subject, do we need another summary of the differences between what's implicit inference and what's implied? I suppose that would be doing us out of a job, really. There's the judgment. We should make of it what we will and pass it on to those interested. So I think, it's a useful judgment, and I applaud it.
Okay, and I would agree with pretty much what you have both said. I'll conclude by using the words of Dr. Yap in his article. It's a pragmatic decision that hides a lot of things, this word, pragmatic. Thank you very much. Bye-bye.
Bye.
Thank you, bye.